can't, if this matter can't come to Supreme Court, then the Lordship will consider what would be the focus of 32. That's point number one. Point number two, I am seeking an SIT. There can hardly be an SIT of note within Assam for the boss of Assam.
The High Court can take the people from outside. We have been doing in High Court. It's not first time that happens.
Your Lordship has full discretion to go under 32. There is no mandatory bar. This is asking for the number one person in Assam, and therefore there is a certain distance from Assam which is necessary. It's an appropriate case for 32. Number three, I'm handing over a list of 17 cases where my Lords has, in very similar and much weaker situations, referred it to 32. Just see that. Can you give it quickly? 17 cases.
The problem is that unfortunately, whenever the election will start coming, first of all, we will earnestly appeal to the parties, political parties, whosoever they may be.
Yes.
That mutual respect, a sense of restraint, and whatever you want to express your opinion, that should be within the constitutional moralities, constitutional principles, or whatever the law of the land that we expect them to.
With equal.
But this is also a new emerging trend that whenever the elections in A state, B state, D state come, this court becomes a political battle.
My Lord has made that observation, and rightly so in many cases. Kindly consider if this is right in this case. Who has started this? 5 statements quoted. Your Lordship's words are entirely well taken. But do they fall beyond sermon for persons like this? He's an habitual, consistent, continuous offender. Allow me, just allow me 5. Then
I'll place all these arguments before the High Court.
No, please allow me to place my case. Lordship will then send me to the High Court. Kindly first see this sheet. Kindly hand over the sheet. I'm answering 32, and then I'll tell Lordship why.
Yes.
The Supreme Court, this would be an ideal case to exercise its duty to protect constitutional pillars. So your Lordship entertained Arnab Goswami, Bilkis Yaqub, Vinod Dua.
These are the most of the cases are those against whom some coercive or penal action was being taken by the state authority. Yes. They approach this.
Also,
you are wanting action to be taken against any XYZ. That very action can be well taken by the High Court.
First of all, this is not XYZ,
Which are definitely to some extent wider than our powers. Even if there is a violation of, suppose, forget about the High Court comes to the conclusion that instead of fundamental right, the human right is violated. High Court can still take the remedial action.
No, High Court's power, I'm not in doubt. But why was 32 created? 32 was created for mega cases.
This is not the first case. Last couple of months, I have been telling, and particularly after coming to court number 1, please don't undermine our constitutional courts of High Courts. This is absolutely a disturbing trend that every matter lands up in Supreme.
Right. No, this is not every matter. May I say, the 17 matters.
Unfortunately, in this country, what has happened? By establishment of various judicial or quasi-judicial tribunals, we have already deprived the High Courts from, say, for example, in commercial litigation, in environmental litigation, you don't allow.
Those may be aberrations, and I would not support them.
No, they'd be wrong. Generally, we are pointing out. But a judge who has tenure of 10 years, 15 years, 17 years, 20 years in High Court, you don't allow them to learn environmental law, commercial law, then suddenly they come to
is this that kind of a case? There are cases.
This matter you want to decide.
There is no one size fits. So therefore, allow me to place my case. There is no one size fits all. Your Lordship will not subsume 32 under 226. If the principle is that your Lordship can never intervene because High Court is always available.
Please come to us via the constitutionally prescribed route.
That may not be an absolute rule.
Any litigants. We are always open to.
Well, I have given 17 examples of entertainment. Now just see 3 pages and then Lordship will decide. Come to my learned friend says, Mr. Tushar Mehta are not there when the matter was passed over, said that the person who loaded 145 onwards has been punished. Leave it aside for a minute. Come to 140 onwards. Just go to 140. Then Lordship will see if this is not an all India nation affecting principle.
Yes.
And if these people are not even actioned on the ground of maintainability, there would be, I would submit, a diminution of the rights. Come to 140 bottom. I'll show 3 pages and I'll ultimately your Lordship's discretion. There is no absolute bar. A constitutional post holder sworn to oath.
Yes.
Bound by 14, 15, 21, all individuals.
Become a convenience form shopping only because it suits some lawyer in Supreme Court. Therefore, every matter is filed in Supreme Court. What about the High Court's bar? There are leading lawyers. They are also available.
But
they will
argue. Never ever
can appear online.
Then your Lordship will never
ever. This is not the ground for us to entertain these petitions.
Kindly see 140 below.
We are
My
studying
idea
how to deal with our own areas, first of all.
Well, kindly see bottom of 140.
Yes.
My idea is to create an atmosphere which they cannot stay in Assam.
Yes.
Don't give them land, don't give them vehicles, don't give them rickshaws,
Yes,
don't give
that is
them
the problem.
villas.
That entire effort is to undermine, demoralize the high courts, which is not acceptable to us.
Country.
There is a very calculated move. There is a calculated move to undermine the authorities of the high court. Their constitutional courts enjoy more power than us.
Well, as your lordship is talking of demoralizing high courts. Here is a person demoralizing the constitutional ethos of the country.
Go and file complaint against him.
127.
Go and approach the high court against him. Who is stopping you?
Well, no FIR is being registered. None. Every technical
Therefore,
objection, the state is in
same
charge.
set of relief, Dr. Singh, tell us, the same set of relief which you are asking, can it not be granted by the high court?
Well,
It can be.
practically yes,
High
practically
court
no.
can grant more than that.
Practically no, with great respect.
Practically no.
In
That is the
state of
problem.
Assam,
Practically no, because,
state of Assam,
Yes.
Malas, where will I file an FIR?
Yes.
Where will I get redress?
yes,
Well, if your lordship doesn't agree with my next two arguments, lordship will send me to another high court other than Assam. I will go there.
we
Kindly
will
see
not-
now, Malas.
This again, this is a very serious aspersion you want us to cast on the high court. That's very unfortunate argument. And I outrightly reject it.
Now come to 127, Malas. Kindly come to 127. This is one statement in 140. Now come to 127, Malas.
I have to run the judicial administration throughout the country. If I start shifting the jurisdiction of the high court,
Arguing for 32
it will
by your lordship.
what kind of consequences?
Nobody else, Malas. I'm saying only 32 by your lordships. Now kindly come to Malas 127 bottom.
Yes.
Sharma and the BJP are directly against the MIA, proclaimed during a conversation with journalists on 27th January. During the 3-minute exchange, Sharma urged the people of his state to give the MIA trouble and practice the politics of polarization.
Go seek an inquiry.
If this is not a 32
If
matter,
suppose,
Malas,
if
what
these allegations are, suppose these allegations are not denied, the nature of directions will be different. If these allegations are denied by someone, the nature of directions will be different.
kindly consider
Given an opportunity to the high court to
the
examine,
constitutional fabric and ethos of the country is threatened, when will 32 be there? Otherwise, lordship will Malas put it below 226.
yes,
Everything can go to
no question of 2026. If you don't get the desired relief in 226, please come to us. We will examine.
Now,
We cannot
Malas,
think
see,
that our doors are
for,
closed.
for once in 2023,
Something
it's a
which
habitual.
happens, suppose a matter which cannot be handled by one high court,
Yes.
which has an impact on pan-India basis. You are absolutely right. We must exercise our
This
32
is
power.
pan-India, Malas. This is pan-India. Kindly see
How
what he's saying.
pan-India? It is
He's saying for the
pan-India, one
entire
state.
community, an entire religion, and brazenly.
Tomorrow something will
constitutional
happen in a state, then why not that high court? So the entire country's litigation then should land up in Supreme Court,
No, Malas,
making
that
it
may be an extreme
completely
proposition.
unmanageable affair for us with 33 judges in hand.
Malas,
we
your
will deal
lordship,
with all these.
I have given 17 examples of entertaining
The
32.
only power,
Those are lesser matters, Malas. Coercive action is
Power-
lesser matter.
fortunately, the only power which is surviving intact with the high courts is that of 226. Somebody has not been able to amend 226 thanks to basic structure. Otherwise, high courts will be deprived of that.
Consider 17 cases, if your lordship puts it on the ground of coercive, is a lesser threshold. This is a threshold on the constitutional fabric.
Yes.
So it is higher than those 17 cases where my lord has entertained 32.
So is it not?
Your lordship has entertained 32. Your lordship has no absolute bar, Malas. If the Supreme Court doesn't act here, where will it act, Malas?
Lord, may I supplement?
When will it
There is
act?
no absolute bar. Once we are satisfied that a matter cannot be dealt
Malas,
with
there
by
will be
one
no
high
matter in
court
public law.
effectively,
Malas, kindly,
it will entertain those.
my lord is right. No matter in public law will not be entertainable in 226.
It's
226
only
is wider
because
than 32.
unfortunately that
There will be no matter in public law, Malas. That test can't be. With greatest humility, I say,
we are
that test
entertaining.
cannot be because there is no matter not entertainable in public law under 226. If at all, it is wider than 32.
Please go
Let
to
your
high court.
lordship-
We will
Lord,
request the high court
may
to
I
decide.
just
It
supplement?
will
In the
entertain.
debates, fellas, 32 was opposed. You are giving the power to
32
High
is
Court.
32 in
Dr.
terms
Ambedkar
of,
said that
when the
32 is given
question
a
of-
very special sui generis powers to your lordship.
yes, what is the, by the way, what is the constitution scheme of, let us have then one day debate in court on 226 only. Let's go into the Constituent Assembly debates also. When we talk of access to justice, the 226 is creation of that principle, so that people could approach the nearest high court
So let
and
me-
force their fundamental rights,
Rephrase it,
and
let's
force their
rephrase it.
human rights, and force their civil rights.
Let-
That's why larger jurisdiction given to the high courts under 226.
So let me
We
rephrase.
all three have been through high courts, that's why we know it very well.
All of
The
your-
value of 226.
Most of your lordships come from High Court, but that's not the point. Let me rephrase it.
Yes,
No doubt 32 and 226 are concurrent.
yes.
Number 2 principle. My lord has no bar in 32, a discretion to entertain or not.
Absolutely.
Number
We are not
three.
saying that we don't have
So
jurisdiction.
point number 3. Please ask yourself the question, how and when the discretion is not more apposite than this case to be exercised,
Yes.
is sitting
That is the
constitutional
difference.
oath holder,
Difference of
sitting in
perception.
position, is saying all this
Exactly.
brazenly and every day.
Exactly, that is the
Well, what
difference of
justice happen in the
perception. You are
state
asking
zone?
direction against one state, you are seeking direction against the state administration, you are accusing someone who lives in that very state, you are also mostly resident of that very state.
No, no,
So
no.
it is convenience,
For
appropriate for all of you
Well,
to
but
fight the matter in the High
convenience
Court.
not matter in a
Let
matter
the
like
High
this,
Court-
because convenience may be very low threshold. Incidentally,
Just pull out
and
the chat-
partly anticipating this, we have annexed.
And-
Yes.
This gentleman, I don't know what word to use, Bilus,
Yeah.
has spoken this in Assam,
No?
Jharkhand and Chhattisgarh. It's a multi-state offense as far
Yes.
as statements are concerned. We've annexed that. So if your lordship is talking of multi-state, then it is not only Assam. But
Yes,
how can there be justice in a SIT
We are
or
only
an FIR in Assam?
We are confining to what is alleged before us.
Lordship, just
No,
three
I mean,
points.
I just,
To 3 points to supplement Dr. Singhvi. Lordship, first, there is an order of my lord where my lord has said that in case an FIR is not registered in case of hate speech of such rank nature, contempt
Can I take leave?
will be maintainable against the officers who don't. In this
In the
case,
Supreme
Lordship,
Very right, that is not the contempt
and
before us.
contempt maintainable before this court, Lordship.
Number one, there is no contempt before us. Number one. Number two, you have not even gone to High Court seeking that direction. If we understand in a case where you don't get the desired relief before the High Court and someone comes to us, it is our duty to entertain. We have to provide that. We can't left the litigant to remediless. We will entertain it. But we are only we are objecting to is this shortcut method which is being adopted.
Lordship, I'm
Only because Supreme Court gives bigger platform for bigger highlights, thanks to media, it will reported
Not
in
at all,
media, it is reported in all the. Why the Supreme Court should become a playground for playing certain.
Lordship, I'm merely pointing out the seriousness with which my lords have treated these cases. Second, Lordship,
Respect
once
your High Courts. Respect your High Courts. Go to them. We will request the High Court to expedite, give the urgent hearing to all of you. Whatever grievances you have faith in a system, and that system starts right from. That's why all three components of judiciary are recognized creation by the Constitution. So therefore, under our anxiety to have invoking one jurisdiction, we must not undermine the other jurisdiction.
I appreciate Lordship. Lordship, just second point. Lordship, I'll place my points and my lord will decide. Lordship, the second is that once it is posted on the internet, Lordship knows it becomes jurisdiction neutral. There have been reports of complaints filed in other states. Lordship, now complaints in other states against the sitting chief minister of one state. Lordship will.
If the complaints are filed in those states first, suppose they take action, he will have to come. Whosoever is the accused, he will come. Let us see what remedy he avails. Number one. Number two, those persons who have filed complaints, if their complaints are not entertained in those states, they will go to their respective High Court. That if the alleged offence has been committed within the territorial jurisdiction of that High Court,
Lordship,
undoubtedly that person will approach that High Court. Why they should come to Supreme Court or they should go to Gauhati High
I'm
Court?
merely pointing.
They will not.
Lordship, please. Lordship,
You are right.
Lordship, please. I'm merely pointing out the multi-territoriality that exists today, where multiple complaints have been filed in multiple states. No FIR has been registered in any state. So, in that sense, multiple 226 petitions will have to be filed.
Therefore, any cause of action that has arisen within the jurisdiction of a particular High Court,
Lordship, please.
we are absolutely confident. We are not saying hopeful. We are absolutely confident that the High Courts will deal with those matters strictly in accordance with the law. The principles of, we appreciate, the principles have been laid down by this court, not in one, numerous judgments which you are citing.
201.
Avail those principles are, the High Courts will follow those judgments.
Lordship,
It's only because some people who have, let's not say further because unnecessarily it will prejudice.
Lordship, and last point, Lordship, is that the inquiry may have to be by an SIT of officers from outside the state of Assam. That is my last point, Lordship, in this.
This prayer, if you will go through some orders, you will find as a High Court judge, I have granted this prayer. As a High Court judge only, I have been granting this prayer. There are numerous you will orders fined by the High Court. Once the High Court comes to the conclusion that this in a particular set of cases, that they have to ensure a fair and independent investigation. What should be the mechanism? The courts will find out. Why High Courts every day are directing CBI? Only because in those matters they don't trust the local police.
Lordship, please.
And every day you people are seeing those orders. Some of you are sometimes challenge those orders also. So therefore, it is not the High Courts know their mechanism, but is to be adopted. Please have faith in that system. If otherwise, will it not become unmanageable affair that this sensitivity, so-called sensitivity, so-called certain issues they may emerge in 10 states, 15 states, and every matter the High Court, Supreme Court should hear them. Do you think will it be possible for us to?
I appreciate Lordship. Lordship, we were just trying to distinguish this matter in particular because it involves the constitutional head of a state, Lordship, and therefore the seriousness is also one of the reasons
We
why.
would appreciate if all of you go through the channel, adopt it, trust your high courts, approach them. We can only request the high court that yes, if the matter comes where the question of fundamental rights, the question of liberty, question of any other human rights are there, they should also entertain those petitions with that the prioritized sense of importance that the matters require kind of out of the hearing.
Look, may I just say 2 words just to supplement? I won't repeat anything. I'm appearing in 22.1, which is filed by 4 very eminent civil society. No, I'll just make a point. The 43, these 4 were part of 43 who addressed a letter to the Honorable Chief Justice of the Gauhati High Court, which is at page 160. Expressing the anguish and itemizing all these various speeches which were taking place and these things which were taking, and requesting the High Court to take suo moto cognizance of it. And that letter is at page 160. So it's not that we didn't approach the High Court. We waited. Nothing. There was no response at all.
Suo moto and filing a petition. Once you file petition, Mr. Singh, you have a right to be heard. Nobody can deny.
Yes.
Suo moto is the prerogative of the court, right?
Quite so. But I'm just saying we did. It's not that we didn't at all approach the High Court. Though perhaps it may not be the best way that we did it, but it's not that we
are not saying. 2 things let's make very clear.
Violence.
Some of the persons are eminent personalities. There is no question of de-attributing anything. Some of they have lived their own public life. They have their experience.
Former DGP of police of Assam, etc.
We are not concerned about ideology or anything. Somebody is communist, somebody is BJP, somebody may be Congress. We are not concerned about that. They are persons who have rich experience on their side. They are eminent persons in this world. That's why we get more disturbed when they say that we don't want to trust the High Court in a way. That is what heartening us.
Just one more point, Brother. My learned friend, Mr. Dr. Singh, we just mentioned it in passing, but it's important. There are specific instances in the state of Jharkhand, in the state of Chhattisgarh, where the same learned respondent number 3 in our petition, the same chief minister has made the similar hate speeches in the course of public meetings and so on. So it's not entirely, though the bulk of such statements have taken place in the state of Assam. And there are, I'm not saying that it's widespread, but there are actual instances which each one of them is an offense under the law of the land in Chhattisgarh and Jharkhand in this case.
Mr. Singh, we are quite confident and sure the High Courts find out the ways and means how to exercise jurisdiction, in what matter it should be exercised, to what extent it should be exercised. There are well-defined legal principles. There should not be a difficulty for any High Court to appreciate those.
I only wanted to say this, and what fell from your lordships that if we are relegated to the High Court, your lordships would request a very urgent attention to be paid to it. That would definitely be helpful.
These writ petitions have been filed under Article 32 of the Constitution, seeking various directions against the official and private respondents. So, in our considered view, all these issues can be effectively examined, adjudicated by the jurisdictional High Court. We therefore see no good reason to entertain these petitions before this court at this stage. Consequently, without expressing any opinion on merit, we relegate the petitioners to approach the jurisdictional High Court. Since the petitioners have asserted that the matter requires urgent attention, we request Honorable Chief Justice of the High Court to provide expeditious hearing to the court. That's all.
Well, if some word could be given about constitutional functionaries in general, we expect ultimately, we expect leadership in this country. In every state, it's not this divisive sort of thing is so counterproductive for everybody. It's not that it helps X or helps Y. It's counterproductive for the entire nation.
Absolutely. You see, general principle is all like. Our problem is that today, once we take a view that we should not entertain, we will not be able to even comment on anything, because that way sometimes unfair to either of the side. That is what we are saying, that please go approach there. It's not, Supreme Court is always open to, every litigant is any public spirited person, they are all most welcome. But please come, first of all, have some, is a system which is inbuilt and which the constitutional scheme completely envisages. Let us respect that system, and in that, within that framework, yes, whenever the stays come, the Supreme Court will surely consider everything. Liberty of ordinance, the reputation were displayed.
Grateful, Lord.
Please, Your Lordship.
Next item, 25. 25.
Please, Your Lordship.
Go ahead, who's on bail?
Online betting minutes, cricket betting matters minutes.
On bail.
Co-accused, two accused. There are 23 accused minutes. 2 are on bail minutes. He was apprehended from Dehradun minutes. Almost 23 people have been arrested minutes. So
How
that
many cases against this person?
Manoj, I have no criminal antecedents.
no criminal antecedents.
There are 23
What's the
total accused with 20 witnesses in terms of the charge sheet filed on 13th.
He was the
इसका कोई केस नहीं.
he was part of the organized online betting network minutes.